Thank you very much. Good afternoon. Thank you for inviting me. I studied in Budapest and I always enjoy coming back. And I had contemplated on the topic of my contribution and decided not to cover illegal waste treatment in Czechia. If you're interested in an in-depth study, I suggest to you to open the journal, the last number, to see not only the legal regulation, but also the case law of the Czech courts and also the analysis of enforcement practice. Instead, I noted that the academy itself is sometimes described as a hub of researchers, of young researchers, or older researchers, but of researchers. And I thought, well, as a researcher myself...
Why did you look at me?
No, sorry, it was just something in my eye. I thought that I always appreciate when I know what's happening in other countries, and it's quite easy to come across legislation, but quite difficult to keep with touch on new case law. So I went through a case law from last year and decided to keep those or pick up like top 10 judgments that could be interesting for you or could inspire you in your research practice. To introduce myself, I'm a colleague of Jiří. We're just a small department located in Brno, but I guess we have already some experience in educational research. I also work as a legal advisor at the Supreme Administrative Court of the Czech Republic, which is the main body that deals with environmental cases. My task is to explain the multi-layered background of environmental cases to judges. In Czechia, they are not specialized, so sometimes it's a bit difficult to deal with all aspects of those complex cases. We do have, I would say, up to 3,000 cases at the highest level, and of those, I would say 200 lower level, 100 are environmental. I'm saying this because they are all accessible, so you can find all the decisions of the Czech courts, you can access them, they are available in different formats, including HTML, which you can easily translate with Google Translate. And also we've implemented the ACLI number, so you can also reach them via the ACLI search engine at the European level. If you're interested into making research and going into Czech case law and practice, just feel free to contact me or my colleagues. Now, as regards the cases, I told you I'm not going into waste management, but I think some of them are very important or interesting, even concerning these areas. I'll start with a case that is not even an environmental one. That's a tax case, but it's a tax case in which the court confirmed that the requirement of direct application of EU law applies not only to the courts, which is then emphasized by the case law of the Court of Justice, but also to administrative authorities. That's what you can read in the books, but there's not much case law, at least to my knowledge. So even environmental authorities must put aside not really, the law, not really act, because they can't do that, but all the bylaws that are under the level of regulation of those common acts, they must be able to do that in order to apply the EU law effectively. So when it comes to certain fields such as waste management or others, this could be really helpful, and I think that was the idea or intention of judges to stress it's not just up to them, but also of the official bodies. The second one illustrates the depth of the judicial review. Throughout the time, more and more frequently, the judges deal with technical issues, and this is probably the first judgment that deals with exceptions from the best available techniques used in the industry. This applies to air pollution, but the same way can be applicable to waste management. So that's one of the conditions under the Industrial Emissions Directive, but to my knowledge also, I'm not aware of any similar cases in other countries. So this is quite interesting because the courts, they actually confirm that an exception is possible, and they elaborated on those individual conditions and made some reference to the case law of the Court of Justice. We even had a case from which a preliminary reference was made to the Court of Justice concerning the IPPC procedure. It was whether actually only the adjustments of the time of the industrial activity can be considered to be a serious amendment to the permission. The Court of Justice answered in a negative way. It said no, which means that, for example, public concerned is then not allowed to participate in the proceedings. So it's also quite a new case. It's, from my knowledge, it's C43/21. It's once again the first case at the EU level. Now, this was concerning a power plant, a coal power plant that's located quite in the middle of Czechia. It's one of the largest sources of emissions in Europe. So once again, it's not just our national, I would say, issue, but more transboundary. When it comes to transboundary issues, the courts also recognize the rights of affected foreign citizens. So it's not just about the public affected from the Czech Republic, but also courts, they allow or confirm that even the individuals and the NGOs from other countries must be able to access courts in Czechia. Once again, to my knowledge, this is often interpreted in a restrictive way in some countries, and they do not allow, especially the NGOs from other countries, to interfere into the proceedings or to access the courts. So we do. This, I think, is in line with this more extensive approach to NGOs in my country. I don't know how many NGOs in your country, like unique individual NGOs, reach the court. Is it 10? Is it 20? There are no numbers, actually. So I don't know if you have this overview of what's happening. Maybe the Hungarian ombudsman, if you cooperate with NGOs. But usually it's around 10 or 15. In Czechia, in the last 20 years, we had more than 200. So more than 200 individual NGOs that are able to bring the case up to the highest level, which I think is quite unique. To illustrate this, also the courts, they allow even the newly established NGOs to reach the court. So even after the decision is adopted or a land use plan is adopted, still you can set up an NGO and reach the court. So quite extensively, I would say. That does not mean that the NGOs are always successful at the court, but at least they are allowed to reach the court. Now, there is a very interesting decision that was adopted just at the beginning of this year, in which the court opened a possibility of the NGOs to challenge even animal welfare decisions. You know that animal welfare is usually subsumed under agriculture policy, not environment. But they basically said, well, you have to reconsider it because we think that what's happening to animals, it's not just, closed door. So there is some effect on the environment in the wider sense. So we're quite looking for the next decision because this is not final. This is just, you have to do it again and do it a better way. But also, to my knowledge, this is quite new. And you probably know that the new European Commission has set up a new directorate for, I think it's public health and animal welfare. So even at the European level, it was taken from the agricultural policy to have this nice package with public health. So we'll see, maybe that goes in line or maybe against. Now, this is a bit more complicated, but this judgment only emphasizes that if there is a question whether there must be environmental impact assessment, it should be answered at the very beginning. If there is no impact assessment, then in relation to participatory rights, which means that if there is a question that NGO may participate or individuals, you have to also answer whether actually the project is subject to the environmental impact assessment. The NGOs may even challenge public law contracts, which makes sense, but it was for a long time a way how to avoid those formal procedures. So finally the court confirmed that it is possible, even though it is usually open only to the parties to the contract. So it was not really happening before that. Number 8, and it is a broad freedom of speech. I don't know what's the situation in Slovakia or in Hungary or elsewhere as regards those climate protests and so on, but we already are gathering some case law regarding, blocking the roads and so on. This is not really about blocking the road, but it's more about advertising, using information, using sarcasm, humor, but still being very critical to either state or state companies. This is the largest. This is the largest energy company in Czechia. And it went up to the Constitutional Court and it said, no, there is a broad freedom of speech. You can protest. I mean, there are some Polish colleagues. I think that this year there was this case, Friedrich versus Poland, that made it to the European Court of Human Rights. Also, it goes a bit hand in hand. Now, this is quite a very nice idea that the courts for a long time, they ruled that as an individual, you have no right for the proceedings to be started if it's ex officio. But recently this has been overturned, and I think there is this German theory that if your right is at stake, for example, there is a legal building and there is no other way how to protect you than starting proceedings, then it establishes your right. So still you have no right for the proceedings to start, but the right to be protected. And if there is the only way to start the proceedings, then it translates to this right. So this was decided just 2 years ago, but I think that already there are plenty of decisions following this judgment, and it opens this Pandora box that the individuals, come to the authorities and state, you have to start the proceedings, just go on. Even it's ex officio. So that's very interesting. It's a bit close to probably the most famous case that we're dealing with right now, and it's the climate litigation. We have a strategic case on climate protection, in which there are a number of individuals, NGOs and municipalities that ask the climate policy to be adapted in a different way. The problem is that we have no climate act. We have no requirements, imposed on ourselves. So the problem is that towards the EU requirements, we are somewhere in the middle. So it's not 2030, it's 2024. So still there is some time left. And today you've heard that Czechia is not likely to meet those requirements. But can you go to the court now? No, probably you have to wait 5 or 6 more years. But this is very close, that you're asking, for something to be improved that does not even exist. So it's more like you don't want to cancel anything. You want to, build something, improve something. So that's quite interesting. And there are 2. I promised 10, but there is a bonus one. This is the 10th one, that we're also considering building an underground nuclear waste repository. So after France, Sweden, Finland, we're probably like the 4th, very serious about it. And there has been already a decision of the government where to actually locate the underground storage place. But the courts, they denied or they refused to review such a decision. They said it's just political decision at this very moment. So that's, I would say, quite controversial, because it is, based on science. So there is something to review, but that's the way it is. And the bonus one, okay, it's dealing with it's not the Supreme Administrative Court, it's the Supreme Civil and Criminal Court. Very often we have the problem that the thresholds for criminal liability are not met. This was a case in which there wasn't just one dead wolf, there were 2 dead wolves. But the court, they said it's not sufficient, it's not enough for criminal liability, it's just 2 dead wolves. You cannot shoot wolves in Czechia, you can shoot them in Slovakia. So, and these were taken from, these were taken from Slovakia, already dead. And the activity, the illegal activity was that this person could not prove the origin of the wolves. So the court said it's not serious enough. It was not killed in Czechia. It's just about proving where does it come from. But because that there is the CITES treaty and also the CITES regulation at the EU level, and we are bound to have this criminal liability. So we are quite happy that the court said no, because if you cannot prove the origin, you don't know where does it come from. So there is a strict level in Czechia that if it's the most serious category, 1 is enough. So 1 is enough, and then it depends on the sanction. But we are quite happy that this was confirmed, because very often those cases, they just miss the criminal court. To illustrate or to make reference, you've seen the numbers for Poland for illegal waste treatment. In Czechia, I think in last 10 years, we only had 3 successful cases on illegal waste treatment before the criminal court. Everything ends up at the administrative liability, and it does not continue further, even though I think the threshold is crossed. So that's it. Here's the wolf. Just one. I don't have the picture of the second one, but you know, yeah. So thank you.